Are you a real estate investor looking to sharpen your skills or a newbie looking to become one? You're in the right place. Welcome to Where Should I Invest? Real Estate Investing in Canada with your host, Sarah Larby.
Shaneka, welcome to the show. How are you?
I'm well. How are you, Sarah?
Good. I'm excited to have you on. So, I've read lots of great things about you, and I was excited to have you on the show today to talk about, your journey and also your firm and what you do to help others. So maybe we'll start there. Maybe just tell us a little bit of about you and what you do.
Sure. So I'm Shaneka Shaw Taylor. I'm the founder of Taylor Litigation Professional Corporation, and we are a law firm that specializes exclusively in litigation. So what we do is we help individuals and businesses when they're involved in legal disputes. So whether that's business disputes and product liability claims, and particularly with real estate, we have particular expertise with helping real estate investors, property owners, mortgage lenders, borrowers, with anything related to real estate disputes. So I've been practicing for 13 years, love what I do, love helping people craft, creative and interesting solutions. It's not a good time or a fun time to be involved in legal disputes unless you're me. I love it.
That's what they say, right? The only time the only winners are the lawyers, essentially.
Exactly. Right. But I get to help my clients when they're involved in a really stressful situation, get them to, navigate that system, and hopefully they have great things to say about it.
Okay, cool. So what is the difference between litigation and just a regular real estate lawyer that might be working with real estate investors, as an example? Like, I'm assuming that you go to court and you actually go through the process, but maybe just, tell us what the differences are.
So a transactional lawyer is what we like to call them. So a transactional lawyer is someone who helps clients with a transaction. So if you buy a property or are looking to refinance a property, then you would look for a real estate transactional. And that's the person that's going to help you with your paperwork, going to help you either to draft the agreement, review the agreement, register anything on title, remove things from title. So those are the transactional lawyers. Whereas, and we call them solicitors. And then you have the barristers like myself, where we don't deal with transactions. So we don't do closings. We only help clients with disputes, resolving disputes, whether that's in court or through mediation or arbitration. So you have some lawyers that do both, the closings and the litigations. Not very often, but you do have a few lawyers that do both. We only do the disputes side. And the way I like to explain it to clients is, if you think of a doctor, right? You'll go to your family doctor when you have, an issue. And depending on the type of issue it is, your family doctor will then refer you on to a specialist. So if you've broken a bone, they'll send you to an orthopedic surgeon, right? If you have a mental health issue, they'll send you to a mental health doctor. Same thing in law, right? So you have specialists like myself that specialize in particular areas. And then you have some lawyers that are general practitioners.
Okay. All right. That's great. And you operate in, is it a specific region? Is it the entire province? Walk us through what that looks like.
Yeah. So our office is located in Toronto, in North York, but we practice across the province. And depending on, where our clients' needs take them, we can help them with other jurisdictions. So we do work in Alberta. Even though we're not called, we have lawyers in that jurisdiction that can assist us with matters, British Columbia, so across the country, with the exception of Quebec.
That's always the exception, right? Quebec is always that exception. And
Always the exception.
They're always the troublemaker. I'm actually, my family's half from Quebec. I get it.
They're the troublemakers, but the rest of Canada operates under the common law.
Yeah.
Whereas Quebec, it's the civil law, civil code. So you have to be called and have special knowledge to deal with their civil code. But the rest of, the common law, it's similar enough that we can, practice in different areas.
Awesome. So I'm curious, like just like your own personal journey, how, 'cause, it is really awesome to see, how you've built the firm and everything. But, how did that come about? Maybe just walk us through, how you decided to, not work necessarily for another law firm and do your own.
So it's interesting. So I've always wanted to be a lawyer from I was small. And I went to Osgood Hall Law School, went to Osgood. And then after law school, I, did the traditional path. I worked on big firm downtown at Bay Street. And then I joined a mid-sized boutique downtown Toronto where I was there for 11 years, 6 years as an associate and 5 years as a partner. And then I decided, you know what, I really want to focus more on helping my real estate investors and people involved in real estate. And I really want to focus more on the business and commercial disputes. So that's when I decided to, start Tailored Litigation so we can focus and really narrow in on those particular areas in that particular business. So it's been great. We are growing. Whenever there is a recession or, the economy is not doing so well,
You guys do better.
luckily for us, we do better.
So you're right now you're getting lots of new opportunities, I'm guessing, because these are tough.
Lots of new opportunities. But lots of opportunities to help people resolve their disputes, right?
Mhm.
Because a lot of the clients that come to us and they're in a state where they have no idea what the next step is. They have no idea what their options are available to them. And it's not always that you have to go to court. You don't always have to, be involved in a claim. And that's where we come in to really help clients understand what are the different options available to them and what creative solutions they can put in place so that everybody wins.
Yeah, very cool. So you do have a background. You worked on, a few different places and you realized you wanted to build your own company and your own business. Um, okay, so what are the majority, like let's just say you have to put like I'm sure there's no majority, but the majority of like current cases, like what is it? Is it disputes between founders? Is it disputes between like what are you seeing the majority of the things to be and how can we avoid those?
Good question. So I'd perhaps group them in buckets.
Okay. No, yeah, it's
So
totally
the top three buckets that I'm seeing right now are real estate closing that are not going through because of how the market is functioning right now.
Mm.
With the high interest rates, if you take a step back and think, during the good times, 2-3 years ago when real estate was booming, everybody was, getting in the market, particularly on the pre-construction front, people were signing agreements of purchase and sale for closings a few years later. So now when those closings are coming to fruition, we're seeing a rise in lenders appraising properties for less than the agreed upon purchase price. And so there's a delta between, what you agreed to pay for a property and now the financing that you can get, and you can't bridge that delta.
Mm-hmm.
And so we see a lot of people, unfortunately, either having to walk away and are being sued because of that, or trying to come up with creative solutions to get them to close. So that's the first bucket. Appraisal's gone bad, I like to call it. And then the next bucket is, partnerships that are in trouble for some of the same reasons, either a mismanagement, lack of funding, on refis, tenants who are not paying. So, the cost of carrying the property is higher than anticipated. So people, trying to find different ways to exit, joint ventures and different agreements. And then the third bucket of cases that we have are lending defaults. So whether you're on the the borrower side or the lender side, people just not being able to meet their obligations, their payment obligations. And because of that, we are seeing a rise in insolvency applications, bankruptcy applications. That's not something that we handle in our firm, but, we're seeing a rise of that and a fallout of that. So yeah, I'd say those are the three.
Yeah. And there's probably, like you said, more today than there were 2 years ago. right? Because rates have gone up and appraisals are not coming back where they used to. And funds are getting tight for, I think, many investors out there with, having to carry extra on all their properties if they were already, borderline cash flowing at that point in time. So you said a few things, like I think you do mediation. Is that like usually your first course of trying to figure out how to not go to court? Like that's probably cheaper for everybody.
And you hit it on the head. Look, going to court and being involved in a lawsuit can be a very expensive process, right? So, especially in an era where funds are tight and you're trying to stretch your dollar as much as you can, I always tell my clients, that the best outcome is usually an outcome where everybody's a bit unhappy, right?
Mhm.
So, if you can try to get in there as quickly as possible and try to negotiate some sort of settlement from the get-go, you're better off doing that than going through the legal process and the lawsuit process. So informal mediation, informal settlement discussions, I think, is usually the best way. And then there are times when that's not possible and the parties may consider going to arbitration. And arbitration is an out-of-court private process where the parties engage a third party, an arbitrator, to try to help them to resolve their disputes. And that's usually a binding process. And if you go that route, you generally are, foreclosed from going to court. But it's a faster process. And if you don't want to go through that process, there's always the lawsuit option available to you. But yes, I definitely recommend that, clients try to mediate their disputes. It's going to be cheaper for you. It's going to be less uncomfortable in the long run. But as I said, there are times where that's not possible, and that's okay too.
Yeah, no, absolutely. So I'm just going to ask you like some different maybe scenario questions that maybe, some of the listeners are thinking about because many of them are current investors, landlords, buying, selling. So I want to go back to one of the big buckets that you mentioned is when things don't necessarily close. So you've got, let's just say an investor has a house sold and the buyer doesn't close. What are, um, other than, obviously they lose their deposit, but what are those opportunities for that seller to be able to recoup some of that?
Losses. So if you have a situation where the buyer doesn't close, so yes, you get to keep their deposits and you get a court order for that, but you're also entitled to any losses you may have suffered as a seller. So whether that's a difference in purchase price, whether that's carrying costs between the closing date of when they should have closed and when you ultimately find a new buyer and that closing date. So let's say that's, a 3-month difference, whatever carrying cost that you have within a reasonable amount. I shouldn't say reasonable amount. Whatever reasonable carrying costs you have, so like property taxes, extra insurance, utilities, so forth, so on,
The
bridge
mortgage.
financing,
Yeah.
right? Whatever extra cost you incurred that you wouldn't have had to incur had you closed, you're able to recover that difference, right? And you may say, okay, that's 100,000, 200, whatever that number is, you can go and get a court order for that through the litigation process. But as I said, that can be costly. So you may consider, okay, I may be entitled to 100,000, and I may get a judgment saying that I can get 100,000, but I need that money today. So what can we do? Can we negotiate something where, instead of paying me 100,000, you pay me 50, 60, 70, whatever that number is, so that I can get some money today? And maybe you structured, maybe you can't pay me 50, 60, 70 all together, but you can, break down that payment. So I get 30 now, 10 in another month, however you want to structure it. So there are different ways that you can tackle it. But yes, you are entitled to, as I said, a difference in purchase price and certain carrying costs if the buyer doesn't close.
Yeah. So
And if you're a seller, I'm talking about the flip side. If you're a seller that, let's say changes your mind, then the buyer has the option to either ask the court to force you to close, or to ask the court to give them damages, compensation for you changing your mind and not closing as you agreed to.
Yeah. And probably you would have seen a lot of that back when the market was so hot and has gone up so much. And like every single month, it was like a crazy new price.
I actually had a scenario where I had a client who bought a property, seller changed their mind. We had to go to court. Took her like two years to actually get possession of the property. She got a judgment that saying he had to close within like 6 months, and then he still refused to close. And so we had to going back to court. So by the time she actually got physical possession of the property, like the purchase price had been knocked down so much that he perhaps got like less than half of what she agreed to pay to in his hand. By the time like he factor in the legal fees, the interest that she incurred. And between the time periods, mortgage rates had gone up. So we were able to get her the difference in mortgage costs that she had to pay ultimately. So yeah.
It's never a pretty situation. I think a lot of the stuff that I'm seeing right now is sellers selling with a tenant and then agreeing to vacant possession and then realizing the tenant is not leaving that easily. What are some recommendations to avoid that scenario that you have seen maybe work?
Other than cash for keys, which I know everybody's trying to do or avoid doing, I always suggest that you start the process at the LTB well in advance so that you can get an order for vacant possession. And there are certain things that you need to get order for vacant possession, including an agreement of purchase and sale that says that the buyer requires the property to live in for themselves or a close family member. But I think the number one thing is put in a clause in the agreement that deals with, okay, what happens if I can't get you vacant possession? Are you agreeable to taking possession of the tenant, or are you agreeable to moving the closing date until I get an order for eviction? Just a lot of the times, really, it's people not thinking through.
Yeah.
What's going to happen if this doesn't happen? Like, so having a plan B, talking about it in advance and building that into the contract as much as possible. Because a lot of what we see is, people putting in their contracts best case scenarios and never thinking of or planning for worst case scenario.
Yeah. So like for mine, because we just sold one with a tenant as an example, and we weren't sure which way it's going to go, and it might go the difficult route. But keep in mind, and this is it's just for the listeners, and I'm glad that you mentioned this, that in order to issue an N12, unless you're doing cash for keys, which to be honest, I don't really like that because it sets a precedence that tenants get their payout and they, anyways, it's a whole different ballgame. But an N12 can be issued, but you have to have the buyer, right? And the buyer has to be moving in for themselves. And then that process, let's just say they, you give them 60 days, but if the tenant doesn't want to go about this in Ontario, you're probably waiting like 8-10 months before you get your court date. So to go back to what you were saying, is one of the things I make sure that we do in our contracts that are tenanted is like, if there is no vacant possession, then, like both parties agree to either forgo or like whatever, like the agreement is. I think in one we have that we can like push the date out if they still want to do it, or they have the option to buy, to buy with a tenant in there. But I think that's just super important because I think with everything being so high in cost, like tenants are just not able to find anything anymore that are the same price probably than they were currently paying. So there's a lot more problems out there, and the LTB for Ontario, the court system is so backlogged that it's not going to be like you're getting a court order and a date and everything within that 60-day time frame. It will take you a long time, and by that time, is the buyer even interested in waiting that timeline? So there's it's like it puts a lot of landlords in that tough situation with a tenant and trying to sell a house with a tenant that does not cooperate.
Yeah. Admittedly, it has gotten a little bit better.
Okay.
They have the landlord and tenant board. They have appointed a few more adjudicators.
We're at 6 months instead of 8.
Now like 4-6 months instead of 8. It's still awful, but it's certainly better than it was before. And what I will say is like, tenants in Ontario are so sophisticated and they know their rights,
Yeah.
right? So as a landlord, you have to also make sure that you know your rights and the options available to you and deal with that upfront.
Absolutely. Alberta, I think different story, right?
So I don't know.
So what about, like you talked about JVs. I mean, I think a lot of folks out there probably, as they scale, have JV partners, joint venture partners, whether they're active or passive, or maybe some partnerships in some capacity. And, sometimes they don't always go as hand. What are some things that like you might recommend we have in our original agreements, contracts, shareholder agreements, that kind of stuff to maybe avoid some of what you're seeing?
It's always going to be difficult to foresee every single thing that could go wrong. But I think if you, really sit down and think of each provision and what you're trying to accomplish with that provision, and then think on the flip side, okay, if what I'm trying to accomplish with this provision doesn't go as planned, what could happen? And then talk to your, solicitor, the transactional lawyer about, okay, if this goes sideways, what are the potential repercussions and how can we avoid it? And have those discussions with your JV partners. One of the clauses that I always stress that, clients should have is buyout options. And what happens when we can't agree on buyout options, or we can't agree on a path forward with this property? Does that mean that, put time frames? Are we going to sell within a certain period of time? Do we have to go to court if one person doesn't agree to sell? So talk about those things, right? Talk about the different scenarios and what could happen and what should happen so that everybody's clear. So I always, talk about, buyout provisions or sale provisions in JV agreements. Clearly spell out what each party is bringing to the table. So if I'm a JV partner for 20%, why am I getting for 20%? What are the considerations that went into that? And what am I supposed to be delivering for my 20%? A lot of times we don't talk about that, right? What are the expectations for what I'm putting in to the transaction? So I think those are the two that come to mind as to clauses that I think would be helpful. At the end of the day, you would be surprised, but most times, I'd say 9 out of 10, people get into disputes and come to see me because they don't talk about the things that they're thinking in their mind before they get into, these situations. Or they don't know what they don't know. And you won't know what you don't know until you've talked to either someone who's doing what you want to do, or a real estate lawyer that has experience doing what you're trying to do.
Great advice. So let's just say, whether it's a transaction or a JV agreement going sideways, or, any other multitude of things, what are, some things that the client should prepare knowing that they may have to go to litigation, like documentation wise and that kind of stuff?
Good question. I would say receipts. And I'm not talking about physical like receipts. I'm talking about having your evidence, having your ducks lined up. The lawsuits that cost the most money are the lawsuits that are between he said and she said, she said, he said. Those are the lawsuits that cost money. The lawsuits that are cheaper are the ones where here is my evidence of when she said X, or here's the documentation about when, we agreed to Y, and it's clearly set out in writing, whether that's a text message, WhatsApp, photograph, I took pictures. As long as you have documentary evidence to support your version of the events, it helps things go by so much smoother and get the parties to resolution so much faster.
Yeah, no, absolutely. Documents, screenshots of things, file edits, because it's
even when you don't think you'll ever need it, you never know. I say document everything, and you may feel crazy doing it, and you may never need it, but it's better to not need it, get to the end of that transaction or deal or whatever, and be like, okay, I don't need this, I can delete it, than needing it and not have it.
Yeah, very well said. So, I mean, obviously, when people reach out to you, they're, already in trouble ahead of time, which is unfortunate. But it sounds like you have some great insights on the JV piece. What about you talked about the business side of things. So how do is it entrepreneurs? Is it companies? Like who are some of the, not names necessarily, but the types of clients?
So for the real estate front, it's usually, individuals who are really trying to get ahead in life and trying to figure out multiple streams of income. Maybe they have some RSPs that they want to put to use. So they start doing private lending, or going to JVs. It could be individuals who are already, in the business of real estate investing, and are trying to attract investors to them. So it's a mixture really. But I think the majority for me is, individuals who are really looking for a second stream of income and, perhaps have done a few real estate investing transactions and it's gone well and they, rinse and repeat until something doesn't go well.
Mm-hmm. Yeah.
Yeah.
Never, those are never good times, but they're going to be part of the process at some point, along those years. And hopefully it gets resolved early on because litigation sounds like it costs a lot of money. So for, somebody who is a landlord, let's just say, and they have a tenant who has not paid as an example and has, left. Maybe they're no longer a tenant. And I don't know if this is something that you deal with, but I think many of us experience that, right? So like, let's just say a tenant owes X amount of dollars, then they just skip and then they're gone. They're not in that property anymore. Let's just say for simple math, it's $20,000 that they are, owing. Is there a process for that you do, or what are your recommendations?
You can bring them to small claims court. As long as the tenant is in possession of the unit, that's the landlord and tenant board jurisdiction. As soon as they leave, they're no longer within the purview of LTB. So then you can bring a claim in small claims court if the amount is within small claims court jurisdiction. And if it's over, then you can go to superior court. But yeah, even after they've left, if they still owe you money under your contract, you're entitled to sue to recover that money.
Okay. And now is that where your firm would be hired to help?
Yes. So we can help with that. Whether or not we can certainly assist you in getting a judgment for whatever money you're owing. And as I always tell my client, I can get you a piece of paper. It's whether you're able to recover on that piece of paper, that makes the world of a different. So what we tend to do is we try to do a lot of investigation and searches up front so that clients going into the process of a lawsuit have a better understanding of, okay, if you get me a judgment, what's the likelihood of me recovering on that judgment?
So if this tenant, for example, like leaves the house in abuse, obviously like more than just regular wear and tear and there's damages, is that also something that, once they're out of the property, a former landlord can go after them? Okay.
Yes.
As long as they're still in the house and it's an LTV issue, as soon as they move out and they're out, then you can hire somebody like your firm to go after them for the rest of it.
Correct.
Okay. All right. Awesome. So on that note, thank you so much, Shaneka, for being on the show. It's a pleasure having you on. Where can my listeners reach out and find out more?
So they can visit our website. It's Tailored Litigation, TAYLORD, litigation.ca. We are also on all social media platforms, primarily LinkedIn and Instagram are two major ones. Tailored Litigation. You can search for us there. Email me, call me 416-628-9830. Pretty easy to find.
Amazing. Okay, awesome. Well, thank you so much for being on the show, Shaneka. It was a pleasure having you on.
Thank you for having me.
Thanks so much for listening to Where Should I Invest with your host, Sarah Larby. Make sure to listen in next time. We'll catch you on the next episode of Where Should I Invest?